one nation, under God, indivisible, with liberty and justice for all.
Hey. First order of business, approvals of July 8th, 2019 minutes. Does anybody have any changes or additions to the minutes? No. No? I get a motion to approve?
Also move. Second.
All in favor?
Aye.
Minutes are good. All right, next order of business is Rick and Mark Ventura, 1 Lane Gate Road. The applicants are seeking an interpretation of Town Code Section 175-23 that the existing uses on the premises are pre-existing, legally non-conforming uses permitted pursuant to the code, as well as an appeal of April 23rd, 2019 stop work order issued by Code Enforcement Officer. The property is approximately 9.542 acres and situated in a highway commercial HC zoning district in the town of Philipstown. Somebody representing Mr. Ventori? Yes.
Good evening, Michael Soriano.
Good evening, Mr. Soriano.
Thank you.
What tonight's meeting is for is to review the application, see if we have everything we need and if it's complete, and if we have set it up for a public hearing. Just kind of give us an overview of what you're appealing here.
Well, we're appealing a stop work order that was dated April 23rd of this year. The basis of the
Can you
appeal...
speak up just a little bit?
I'm sorry.
That's okay.
The basis of the appeal is that we believe that the current processing of dirt, gravel, and rock on the site by Mr. Ventura is a legally existing non-conforming, pre-existing non-conforming use. And of course, under your statute, section 175-23, and by the law of the state of New York, pre-existing uses may continue despite the change in either the code or in fact zoning. And this property itself had different zoning classifications over the years. Under the 1983 code, it was an industrial I district in which contractors' yards were permitted. And this property remained zoned industrial I until 2011, when it was rezoned to highway commercial. In 1983, the planning board approved a site plan for a contractor's yard, and accessory to the contractor yard use has been historically receiving, processing dirt, gravel, stone, and other materials for use as contractors' materials off premises. And at no time prior to 2005 did your code prohibit the processing of soil, gravel, or rock in an industrialized zoning district. So that's essentially why we're before your board. We look forward to the opportunity of presenting our evidence, making a record as to the historic use of this property up to the present time, and then ask you to interpret your code and determine whether the stop work order was erroneously entered or issued.
Okay. Like I say, tonight is for pretty much for making sure we have everything we need in order for for a public hearing.
Yes.
One thing I found I don't see in here that you didn't submit
Okay.
was a court decision from the appellate court, Supreme Court, State of New York.
There is a appellate division.
Yeah, I have it here.
Appellate term
Let me go through it.
decision, I believe it is.
Let me go through it.
Yeah.
Okay. First of all, I guess the property was given 5 violations, 5 counts of violating Chapter 175, and we went to a court and went with the front of Putnam County Judge Alan Steiner Jr. And he ruled against your client, I guess. Then you went to the Supreme Court appellate, correct? Is that correct? Did you do that?
With prior attorneys. I was not involved.
Prior attorneys, okay. They went to the Supreme Court appellate, and a decision come down from the Supreme Court on March 21st, 2019. And basically it says it's the appeal from Steiner, Judge Steiner, It says it is uncontroverted that at the time the charges were filed against defendant in 2013, the processing of dirt, soil, gravel, rock, or rock crushing was prohibited within the district in which defendant's property is located. However, defendant contends that the use of his property since 1983 for, among other things, the processing of dirt, soil, gravel, and rock, or rock crushing, constituted pre-existing non-conforming uses. In 1933, Local Law Number 2 of 1968 was in effect. Pursuant to Schedule A thereof, the permitted uses of the property within the district in which defendant's property was located, including buildings, contractors' yards, and garages, and accessory uses customary with the incidental to any aforesaid permitted use, subject to the submission and approval of a site plan by the planning board. Local Law Number 2 also stated that any use not specified in Schedule A as permitted is prohibited. The 1983 approval site plan for defendant's property mentions a storage yard, but makes no mention of the processing of dirt, soil, gravel, and rock, or rock crushing. A handwritten notation on the survey annexed to the site plan states stockade fence to hide contractor's yard. At the trial, the sole witness for the defendant testified that rock crushing and gravel stockpiling, among other things, had taken place on defendant's property continuously since about 1983. Even if this is true, defendant failed to show that these uses were permitted pursuant to Local Law Number 2 of 1978 or the 1968, or the 1983 site plan. Since these uses are not specifically mentioned in either document, defendant argues that as the documents allowed him to have a contractor's yard on the property, the uses were legal because they were accessory and incidental to the use of the property as a contractor's yard. No Philipstown ordinance defines a contractor's yard, and defendant provided no evidence at trial with respect to the meaning thereof to support his contention that the use of the property for processing of dirt, soil, gravel, rock, and/or rock crushing were accessory and incidental to the use of the property as a contractor's yard, and thus were permitted uses pursuant to Local Law Number 2 and the site plan. As a non-conforming use cannot be established through use of the property that when the use was commenced was in violation of prior zoning ordinance. We need not decide whether 42 or something was non-conforming. Use was defense and affirmative defense. In any event, failed to show that the pre-existing non-conforming use was legal, and the people established beyond a reasonable doubt that the non-conforming use was legal in 1983 and thereafter. We incidentally note that the evidence due to that trial indicated that the code enforcement officer observed the violations on the southern part of the defendant's property, whereas the site plan solely concerns the northeast part of the property. I guess the judgment was against your client.
On those violations in the Justice Court?
Right. So,
One was not sustained, but four
I'm sorry?
were. Four of them were sustained on appeal.
4.
Yeah, not all. I think there was a fifth one that they did not.
It's still in the works. Okay.
Right.
So,
I don't know if it's in the works, but it wasn't affirmed.
so the client has already been to the state Supreme Court, right?
Correct.
You're not asking us to overrule the state Supreme Court, are you?
No, not at all.
Or what are you asking for?
I'm
I'm
asking-
a loss.
All right. The April 23rd, 2019 stop work order issued by the code enforcement officer postdates that decision. It is a new appealable order to this board, and we have the absolute right to put this before the board. Am I saying this board cannot consider the decision of the appellate term? No, I'm not saying that. You can certainly consider that opinion. Okay. But what I'm saying is that we have not yet made a record, and that decision was based on a record made in Justice Court. And I think you read the portion of the decision that said there was only one witness for defense. We intend to call multiple witnesses. We intend to make a full record, and then we're going to ask you to make a determination. I'm not asking you to close your eyes to that appellate term decision. I'm asking you to keep your eyes open and ears open and listen to our evidence. And if you agree with us, fine. If you don't, then we have a new record to go up on. But it's absolutely Mr. Ventura is right to appeal this new decision or stop work order by the code enforcement officer and to have this board hear it
Okay,
on the
so,
merits.
Just a quick question, don't you think that this decision has collateral estoppel effect?
No.
Why not?
Because there is a new appealable order, and under your code, we have the absolute right to appeal a new order. This board has never, if this board had previously ruled on this very issue, I'd agree with you. But this board never has, and we have a new appealable order. And if you're going to limit this board's jurisdiction to what courts have done, I think we're going to have a serious dispute with that on jurisdictional grounds.
Isn't it the same issue?
No, it's not.
How is it different?
First of all, it's going to be based on different records. So you're going to compare apples and oranges.
Okay,
What records are you prepared to submit on this?
Witness testimony as to the
What
historic
about-
uses.
What about records of the,
site plan?
the site plan and the original site plan and the building permit?
Yes, all of that will be in evidence
Okay,
before your
well, I
board.
think we would need to see that prior to,
Well, he
you
can
know.
have that sent, he can do that before, a couple
Yeah.
weeks before, he can give that to the
Yeah.
town.
That's
clerk.
fine. Be
Yeah.
happy to do that.
Yeah.
Just so in my head, so I know what I'm talking about. What are you, Judge, what are you looking for us to do? As
To-
appeals board?
to-
What decision are you looking for
to-
us to clarify?
To make a finding that the processing of rock, gravel, and dirt on the premises is a legally non-conforming use, and that the code enforcement officer was in error when he issued a stop work order, and you have the same powers as your code enforcement officer or your building inspector as a zoning board, and we're asking you to enter a new order, a correct order, that lifts the stop work order.
Okay, so I know. So you're asking us basically to determine if rock crushing and soil producing is illegally
Non-conforming
on
use
his,
on
his,
this
and
property.
if it is, then that would override the stop order.
Correct.
Okay, I got it now.
Okay.
I understand. Anybody have any questions? Anything else like that?
I make a motion that we deem it, the application complete.
Well, except for.
Well, he's gonna supply those
Yes.
things. If you try and supply them about 2 weeks before the meeting.
We'll make a whole package submission to you.
Right. I don't have my
When
calendar.
is your September meeting?
September, what's the second Monday in September? I don't have a date.
September 9th.
September 9th? Okay, September 9th, there'll be public hearing.
Okay. Do we have to do mailings, or do you do that?
I do the mailings.
Yeah, do we have the addresses and stuff and all like that, or?
Yeah, I usually, yeah.
Okay. And it's September 9th, we'll hear all your evidence and all your witnesses, and then the board will make a decision.
Appreciate that.
That's it, thank you.
Thank you.
Somebody's got to second Vinnie's motion to say the
Oh,
application.
somebody second.
Second.
Thank you.
All in favor? All right, the motion is deemed complete, and you set up for September 9th. Okay. Thank you.
Thank you.
Witnesses, how many witnesses you think you're going to call, is my question. I mean, it's
probably
going to be an all-night affair, I'm just trying to get some idea of time.
Yeah, I would think between 5 and 7,
5 and 7 witnesses,
and they shouldn't be that long each.
okay. They're not going to have,
And I'm trying not to be redundant.
right, okay, and not all of them are going to have an hour apiece, so you know.
No.
Okay, so let's, we're not going to make this a all-nighter.
I agree.
Okay.
I would suggest that we're probably gonna need to change a venue because of the volume of people you're gonna,
Change it in for one, I'm sorry.
for the volume of people that you're going to have, similar to the other larger applications.
You mean that other people are interested in this,
Yeah,
besides the witnesses?
I think you're gonna,
All right,
you'll get a large.
large crowd?
More people fit in here than they do down at the VFW, chairs wise.
No, I was thinking the rec center like we did.
We'll have to talk to Amber about that.
Yeah, well,
We'll figure that out.
just keep that in mind, you may have a change of venue because of the size of this room.
Let me know.
I'll figure it out by the end of the
We
week.
could be under construction by then as well.
All right, maybe you can get, if we can get some kind of idea, I don't know where you would get that from, but,
I'll figure it out by the end of the week. I
Yeah.
can talk to Amber down at the rec center
And I guess we would probably do it at the rec center. Rec center is down on 9D here. She'll give you the directions like that. So I didn't know there's going to be a large, but
Okay.
there is. We certainly want to, make sure everybody is heard. Okay? Thank
Very
you.
good, thank you.
Huh?
I hate that, because I always drive past it first, and I gotta come back.
I know. Well, we'll play it by ear. Old business, any old business? No, any new business? Any new business? All right, what's next?
Go ahead.
I'm waiting for somebody to make the motion, so I
I'll
can
make the
second.
motion.
I'll second.
You make what motion you making? You sure?
I'm not gonna say.
You seconded? All in favor?
Make a motion to
Aye.
adjourn.
Okay.